When do employers have to pay employees overtime? This video unpacks California's overtime laws and explains what to do if the law was broken. That's a complicated question with a complicated answer. So let's look at the law to find out. If you are properly classified as an hourly worker, then you are afforded the protections of California Labor Code Section 510. 510 says that 8 hours worth of labor constitutes a day's work. Okay, well, what does that mean? It means if you work more than 8 hours in a day, you are supposed to get paid 1.5 times your regular rate of pay. Similarly, if you work over 40 hours in a week, you are supposed to get paid 1.5 times your regular rate of pay for all hours worked over 40. Now, the statute doesn't stop there. It also says that if you work over 12 hours in a day, you're supposed to get paid double time or 2 times your regular rate of pay. If you work 7 days in a row and on that 7th day you work more than 8 hours, for all hours over 8 on that 7th day, you're supposed to get paid 2 times your regular rate of pay. This is a very powerful statute meant to reward employees for working longer hours if their employer requires them to work those longer hours. Now, this law does not apply to everyone. If you are properly classified as a salaried employee under the exempt versus non-exempt laws, then you don't get overtime. But there's always the question as to whether or not the employer classified you properly, and we're going to cover that in a little bit. Suffice to say, if you are properly classified as an hourly worker, you're supposed to get paid overtime. The traditional type of overtime violation that people think about is when the employer just refuses to pay overtime. Unfortunately for those employers who simply refuse, the law is what the law is. And if your employees work more than 8 hours in a day or more than 40 hours in a week, you have to pay overtime. Off-the-clock cases, very common types of overtime violations. This is where the employee is asked to show up 15 minutes early to work every day, but not clock in until their shift starts, or when they're asked to clock out at the end of a shift and just keep working, but not record the time that they're working. Or when an employee is asked to work through their lunch break. Not only are there a host of other violations associated with that, but if the employee works through their 30-minute lunch break and it works an 8-hour shift that day, that's 8.5 hours of work. Half an hour is attributed to overtime pay. Piece rate cases, these are very common. This is where the employee doesn't get paid by the hour, but they get paid per unit accomplished. This is very common in the construction industry and the auto repair industry. If you work on a piece rate and you feel like your compensation structure is funky, call a lawyer. Those are very complicated cases and potentially very economically viable. Meal breaks, we talked about that a second ago, so common in California. On-call cases, this is where the employee is expected to be on call during off-duty hours. Well, sometimes overtime laws apply to that. So you want to make sure you contact a lawyer about those. Those are complicated. Travel time cases, and I'm not talking about the trucking industry, but if you're an employee, you work for a typical company and they ask you to do something in the middle of your shift, I'm not talking about commuting to and from work, those are exempt, but if you're asked to drive somewhere in the middle of your shift, that is hours worked. And if they do not properly compensate you for your overtime hours for that travel time, there could be a violation and you should contact the lawyer. And by far the most common type of overtime violation are misclassification cases. We're going to talk about that right now. Everybody knows if you get paid a salary, you don't get overtime. But we get phone calls all the time from people who get paid a salary, but they're not a manager. They're just an everyday employee. And they're working a lot of extra hours. And they're asking us, hey, should I get paid by the hour? Well, the answer is it depends. This is commonly called a misclassification issue. So to make this as simple as I possibly can, the difference between a salaried employee and an hourly employee is not decided by the employer. It's decided by the law. And the law decides that based on the employee's job duties, not based on titles or anything like that. It's based on what do they do on a daily basis. So let's unpack this a little bit more. A salaried employee is somebody who exercises significant discretion. They have independent business judgment. They have to get paid more than 2 times the state minimum wage, and an exemption must apply to them. Now, without getting into it, there are 6 exemptions, and they're outlined in the wage orders, and they're very complicated. So if you feel like you should be paid on an hourly basis, and you're a salaried employee, you need to call a lawyer to see if one of these exemptions actually applies to you. But let's make it a little bit easier to understand. Generally speaking, a salaried employee is somebody who exercises significant discretion. They decide what to do. They tell people what to do. They can hire and fire. They can decide people's wages. They can give performance evaluations. This is somebody who has significant discretion. An hourly employee is generally somebody who kind of follows a script. It's a production level employee. Think of an assembly line. And those hourly employees don't have discretion. They don't have the ability to tell people what to do. Now, here's something that kind of throws a twist. Let's say you're a manager, but you only spend 20% of your time doing managerial type duties. The other 80% of your time you're working a cash register, you're waiting a table, you're doing a basic assembly line type job. Well, likely, even though you're called a manager, you should get paid by the hour, because if you're spending more than 50% of your time doing non-exempt hourly work, you should get paid overtime, and that's what the law says. So again, this is pretty complicated, but leave it at this. If you're getting paid a salary and you feel like you're working a lot of extra hours and you're not a big wig at the company, you might want to call a lawyer to find out if you've been misclassified, because if you are working a lot of hours, you might be owed a substantial amount of unpaid overtime. If you have an unpaid overtime case, what kind of remedies are available to you? Well, California Labor Code section 1194 says that you can get 4 specific types of remedies. First and foremost is your unpaid overtime. That should be obvious by now. Secondly, you can get interest on the amount of money that you should have been paid, when it should have been paid to you. Third, you can get the costs of the lawsuit. You have to pay various court fees, or your lawyer will pay for you various court fees and deposition costs to pursue your case. Finally, you can get attorney fees. This is very important because it is often larger than the unpaid overtime claim itself. And that way, it's a very significant hammer to get these defendants into settlement discussions early on. But what's really important when talking about collecting money in an unpaid overtime claim is the statute of limitations. Depending on how good your lawyer is, it's a 3 or 4 year statute of limitations. So this is super important. And without getting into any detail, let me say this. If you just quit, or if you were just fired from your job, you don't want to wait even a couple weeks to contact a lawyer. You'd want to contact a lawyer right away and file your case, or talk to the lawyer what you should do. Because if you wait even a couple months, the statute of limitations on the back end might erode away your damages day by day very slowly. So it's very important that if you have an unpaid overtime claim, or you think you have an unpaid overtime claim, or if you think you were misclassified and you were working a lot of hours, contact an employment lawyer for a consultation to figure out whether or not you should pursue it, or whether or not it's something the Department of Labor can handle, the Labor Board, or whether it's something you should just let go. It's really important to get that consultation done sooner rather than later. That's all I have for you today. Take care.